My name is Seth GoldStein. I'm presently an attorney. I also do consulting and expert testimony. I was previously a police officer for the city of Berkeley for 13 years. Worked there as a cadet and through as a police officer. Worked for the Santa Clara County District Attorney's Office as a result of my developing some expertise in working with sexual abuse victims in the police department, where I worked in their sexual assault unit doing mostly child sexual abuse cases. From there I went to the Napa County District Attorney's Office, where I worked as a District Attorney's investigator as well as the project director for their child abuse vertical prosecution program. And during that time achieved through the multidisciplinary concept, which I've adapted to my own law practice now, a 96.5 conviction rate during the time that we were handling those cases. A model that has been heralded throughout the prosecution field as a way to successfully prosecute child sexual abuse cases. As an attorney, I represent mostly parents who are involved in custody cases where domestic violence and child sexual abuse is alleged. I testify as an expert witness and provide an analysis for cases and sit what we call second chair with a lawyer who is trying to develop evidence, which is what my expertise is in developing and putting on evidence of abuse. The answer to your question about what is the best approach for dealing with a woman testifying in a case is something that's dependent very much on the particular case and individual. There are some general rules. I think the biggest problem that we have in getting evidence in a courtroom is being able to educate the witness about what's necessary, the things to do when you're testifying and when not to do it testifying. And more importantly, simply being themselves, which is very difficult to do when you've been traumatized and when you're under pressure, and more importantly, when you're recounting trauma. There are some wonderful materials out available for people to find out about what to do as a witness. The American Bar Association has them at their websites. There are a number of things. It's just a matter of looking for those kinds of things to help them. It would be unwise to make general statements about what is the best way to testify, because it's individual to each case. The biggest problem in child sexual abuse and in domestic violence, of course, is getting the evidence in the courtroom. And what's critical is that the person who is litigating those issues finds the right lawyer who understands both the dynamics of domestic violence, if sexual abuse is involved, the dynamics of sexual abuse, and how to get that evidence before the court, as well as have the expertise of understanding either the family law system or the juvenile court system where dependency is an issue. And without that, there is a very, very serious problem in a woman being able to represent herself. I always liken the statement that Shakespeare had said, is that the person who has represents himself basically has a fool for a client. And it's not so much that it's the putting down of the person who's doing it, because often they don't have the money to do that. But under these kinds of circumstances, the kind of stresses, and more importantly the emotions that it bring out, it can be self-defeating. One of the largest problems in dealing with both domestic violence and child abuse allegations is that they've gone on long before the actual case is filed. And the natural belief is that the reason that you're not telling the reason that you're telling about it today is that you're making all this up because now you have some motive or reason to gain advantage, either in the custody case or you're vindictive, if you're a woman I'm talking about. And the things that have to be considered in doing in presenting the evidence is how to explain what happened before and more importantly, bringing evidence out to establish that the allegation or the statements that you're making now are genuine, because not only did they happen at the time that you have brought forth the allegation, but they have gone on in the past, which means that you need to gather evidence to support not only what happened to you, but as often has happened with other people with the same individual having committed these kinds of crimes in the past with someone else. People have to understand in coming into a courtroom is when they come to appear before a judge, a lot of these cases appear very much the same at first blush. It's not until you get into the facts that you can try to sort through as to what's true and what isn't true. And unfortunately, stereotypes prevail. Judges are unfortunately hearing things which are not true, and so having to sort through those which are valid and are invalid are very difficult, especially given the short periods of time that they have to review volumes of information. And how one presents oneself, how one presents the evidence, all has to be thought about in advance, so that there's a systematic approach to producing the evidence in a way that is acceptable and will be believable to a court. The problem with both either stereotypes or, more importantly, the manner in which people present in a domestic violence case is a very difficult thing for a judge to sort out. When the man comes in dressed in a three-piece suit, is calm, cool, collected, and in contrast to a domestic violence victim who is suffering from post-traumatic stress, who is distracted by the anger and frustration of not only dealing with the person who is offended against her, but dealing with the court system, which isn't terribly sympathetic to her. It is a difficult thing for a court to look at, because what they see are factors that he's nice and calm and he's believable, and she has all the characteristics of somebody that I wouldn't believe, and so those are very difficult things for a judge to sort, which is again the reason why evidence has to be presented in a way that is acceptable to the court and palatable in a way that the judge is willing to understand and accept the information that's being put forward. Well, unfortunately, when child sexual abuse is alleged in the context of a custody case, when it's presented to Child Protective Services or law enforcement agencies, they often discredit the statements that are made by the child as attributing it to a mother who's trying to gain advantage in a custody case. And unfortunately, the hurdles that a district attorney has to get over in terms of their ability to charge a case, meeting their threshold question of, can I convince a jury of of the peers of the community that this happened beyond a reasonable doubt, with the kinds of issues that are raised in a situation that arises from a custody case, tells them that they're not likely to get a conviction. And so unfortunately, the family court is left to litigate cases where CPS and law enforcement have either dropped the ball and not followed through in cases, or simply investigated to the point where they realized that they weren't going to be able to prove a crime in the criminal context, nor were they able to establish whether or not something happened in the dependency or juvenile court's capacity. Different burden nonetheless, but still an issue that arises often as to what's true and what isn't, and can we prove this in court. So it ends up with the family court, and unfortunately the burden on the mother, if it's a mother protecting her child, or a father who's moving to protect the child. And the family courts are not set up to do these things. One of the issues that we have to deal with, and women have to understand as well as men who are litigating these cases and trying to protect their children, is that there are preconceptions about children and about sexual abuse. One judge was quoted in a case in, I think it was Carson City, Nevada, believing that men are naturally attracted to young girls, as he described it, from age 1 to 100. And he went on to say that the thing that we have to do is teach them how to control themselves. Well, these are the kind of misunderstandings and misperceptions that we deal with in court all the time. Not every judge believes that, of course, but the point is that there are people who come to as judges. The problem with judges and lawyers and everybody else is that our only recruits are from the human race. So they're all subject to the same kind of foibles as everyone else has, and they come with a belief system that unfortunately is often jaded from coming from the family court because of the kind of advocacy that they see. If they don't see and are not educated by people who know what are going or what's going on and how to deal with those kinds of cases, then they get the wrong ideas and wrong impressions. The questions about a child's credibility all depend upon what the child is describing, if it's something that you can support independently of the child, if it's something that the child is saying which they wouldn't know had they not personally experienced it. These are the kind of factors that go into a assessment as to whether a child is telling the truth. And of course the problem is that if you don't have the right people gathering evidence to be able to, number one, bring it forward, and then number two, interpret it for a court and explain what the significance of that evidence is, you're not likely to prevail. Unfortunately, litigants trying to both investigate as well as put on evidence by themselves can be self-defeating, because the kinds of things that a person who is detached from the emotion and detached from the incidents themselves can think and anticipate. A person who's been through it all, unfortunately, is not able to do that. My advice to any litigant in court, unfortunately, as expensive as it is to get the right lawyer, get the right advocates behind you, and the people who can help you develop the evidence to demonstrate and prove what it is that you're experiencing. It is too threatening for us to accept that there are times when your children can't be protected, when you're not with them all the time. And as a result, we develop defense mechanisms. And those defense mechanisms, unfortunately, play into stereotypical interpretations, which might both prevent us from accepting that a father would molest a child, that an immediate relative or some kind of blood relative might commit that kind of an offense. And as a result, we carry those through life. When it gets to a excuse me, when it gets to a case in when it gets to court, it's the same issues. The people who are evaluating, who are assessing, who are investigating, and who are making these decisions often face these same kinds of misunderstandings about the dynamics of child sexual abuse, and believe, or let me rephrase that, are reluctant to believe that a person such as a father, who, especially a person who's well established, has a business, has a great reputation, presents well in the courtroom, would do such a thing. One of the myths and one of the misconceptions about sexual abuse is that it's committed by people who are, A, not related to the child, or more importantly, strangers, and that a child could be at risk in their own home. I use the phrase to describe this as where children play, pray, and stay, because what happens is that all of those places which were once thought sacrosanct are the place where people's guard is down, where they don't expect these kinds of things to happen, and more importantly, they don't expect the people in those environments to threaten their children. Children are reliable. Certainly children have questions about, there are questions about children's credibility and certain kinds of statements they make and certain kinds of accounts of events that they get. For the most part, children are reliable about central events. And the research, there's ample research out there to demonstrate and more importantly to back up their credibility in a courtroom. However, there are still people who have the misconceptions about children's fantasy, children's molding of their memories and implanting or creating memories that didn't exist. Now, does that happen? Of course it happens, but it doesn't happen to the degree that has been propagated by many people who come forward and say you can't believe children, period, because they fantasize, because they incorrectly remember things. Each case has to be judged on its independent merits, and that's why gathering evidence to support the child that is admissible and more importantly is gathered in the proper format and manner is critical in a child sexual abuse case in a divorce matter.